24 CF 2046. State Florida versus Aki Deshaun Moore. Mr. Moore, this is a detention hearing. Has the public defender been appointed yet?
It's my understanding that they have not.
When I checked this morning, Judge Charles did not have an
I'll
appointment.
appoint public defender.
Your Honor, now that we've been appointed over to Judge to this hearing today, he's not charged with a first-degree felony, it's only a third-degree felony, so a mandatory pretrial detention hearing is not warranted by the statutes. The state, of course, is free to file their own pretrial detention motion whenever they feel appropriate, so we'd otherwise ask for a reasonable bond for Mr. Moore in this case.
Judge, we're gonna ask for the same thing. The state's not seeking pretrial detention. We're gonna ask for a cash professional bond to be placed on the defendant to ensure his presence for the process as well as protecting the community. We're gonna ask for a $50,000 cash professional bond. The reasons being, first, the circumstances of the current charges. Currently, the defendant is charged with aggravated stalking, credible threat. So what happened in this case is, this is the old case.
The judge, allegations in this case include that Mr. Moore went to the alleged victim's house several times, called her several times, even while law enforcement was allegedly there. Some of the statements that he said included about, I'll bomb these crackers or something like that. The statute requires that it be a credible threat for stalking. I probably shouldn't be trying to confuse that too much with something like assault where it's a more imminent threat. We'd ask for a $5,000 cash professional bond in this case, Judge, with pretrial supervision, no contact with the alleged victim. Since most of the contact was phone calls, he of course knocked on her door. We think that he can stay away from her pretty well with those conditions.
So the credible threat, like my colleague stated, one includes a bomb. One says that he's gonna come into the house and make the police shoot him out of there. One statement says, "I'm still over here in Sunset looking dead at your shit. I'm going to come here every night and morning. This is why I'm applying pressure like this, and I'm not going to stop until I feel good about myself." So this is repeated contact. He is clearly within a line of sight of the alleged victim. So the state's position, and it is a credible threat, he has the ability to carry out these threats because he knows where the person lives, knows when they are there, and currently or has the ability to carry out what has stated that he was going to do. Furthermore, what's also relevant in this case or in this determination is the defendant's previous conduct. Judge, earlier this year, January 3rd, the defendant was sentenced to 18 months DOC, credit for time served, for felony battery or a VOP on a felony battery. So this is not the defendant's first time around. Where the state's going to be seeking a DOC sentence as well. So there is a substantial flight risk because the penalties imposed or that we're seeking.
I would object to finding a flight risk. There's been no allegations that he is a flight risk.
So
he's been to prison before.
So it is alleged that make sure I don't get my wires crossed, Judge. So the reason the state is saying he's a flight risk, we have not been able to locate him. The victim has tried to serve a domestic violence injunction on the defendant and no idea where he's at. The cops have not been able to locate this individual.
Is this alleged victim like his wife or something?
I think they were dating.
That's correct, Judge.
Where does Mr. Moore work?
Where do you work, Mr. Moore? You work for your dad's lawn. Judge, he indicates that he works for his father's lawn care service.
Crestview? Fort Walton? What's the name of it? Where is, the alleged victim lives somewhere in, North Okaloosa County?
I would assume, considering we're here, Judge.
That is correct, Judge. I have the address, it's Bar Street,
That's in-
205 Bar Place.
That's in Crestview, Judge.
This is off.
I recognize that
Mr.
address
Ken,
from
this
other
is-
cases.